Welcome to MAM.101, where all of your burning questions get answered about the wrongful conviction cases of Stephen Avery and his nephew Brendan Dassey of Making a Murderer, the Netflix docu-series. MAM.101 is strictly a live session where your questions are answered live, right before our expert panel for expert answering. No matter how simple or detailed your question may be, MAM.101 is designed as your go-to place for making a murderer education. Please have your questions ready, or feel free to just sit in and listen as we welcome today's session of MAM.101.
Well, welcome everyone. My name is Mark Hoddenott and I'm here hosting session 2 of MAM.101. This is a new question answer session that's been introduced to assist people with those burning questions they may have about things to do with MAM but were not confident to ask, or perhaps remembered once and forgot the second time. So the idea today is, as it has been in the past sessions, is to have a panel of people who've been around in the MAM community for quite a while answer the questions that you may have. And I'm going to introduce each one of those people in a moment. The questions that you may have are questions that you need to ask in the chat session of this broadcast. So that's where we'll get our questions from. We will kick it along with some of our own as a starting point, but we're looking for your questions in the chat session. And today's session, as in the previous case, is intended to go for about 45 minutes or so. We'll try to answer your questions very succinctly, and hopefully we'll be able to cover them all. And we're looking forward to assisting you in your knowledge of MAM matters. Could I just say right from the beginning a big thank you to Brad Dassey, who put together that voiceover for me for this session. I hope you enjoyed it. Brad's a very talented artist and does a lot of voiceover work, and I'm very grateful to him for doing that for me, and it also provides a nice little connection to the whole MAM story when Brendan's brother is part of it. So thank you very much to Brad for that. Now, I'm going to introduce each of our guests. They're all very different, all very talented, and hopefully we'll learn a lot from them. Now, I'll just add our first guest to the screen, well, in a static mode. Here we are. I'd like to introduce to you Carrie Mindell. Carrie, welcome to MAM.101.
Thanks for having me.
Carrie does many things. She's from the state of Illinois. She loves researching true crime and genealogy. I came to know Carrie probably about 3 years ago, I suppose, something like that, maybe a little longer. What I did come to know very quickly about Carrie is that she was the person I needed to ask about anything technical or any research matters that I didn't know about, and I don't know about a lot. So Carrie was a wonderful resource for me and undoubtedly for many others on this case, and clearly her skills are wide and deep. And so Carrie, thank you very much for joining us today.
Thank you.
The next person I'd like to add in to the discussion today is Travis Williamson, attorney at law from the great state of Texas. Hi Travis, welcome.
Thank you for having me.
Our pleasure. And again, I've known Travis for a few years. He's obviously he's a professional lawyer, so his knowledge is not just, if you like, to the specifics of matters that we're interested in, but he has a wider knowledge of the law, which helps to add context to the matters that trouble us. So we're very lucky and grateful to have Travis with us to give us those really true legal responses to questions And of course, since we're in the appeal stage of Stephen's case, his technical knowledge of the law, especially as it passes through appeal processes, will be extremely valuable to us all. And so, Travis, once again, thank you for your time today.
Oh, thanks. Thanks again for having me.
My pleasure. And finally, a man that sometimes doesn't need any introduction. He just sings his way into the session. Singer-songwriter Dassey Seabrook from Canada. I call him all-round good guy and MAN enthusiast. Just to introduce Dassey, I'm sure he won't mind me saying this, some say he's a dissident, but he's just a citizen, filling in as a filament and shedding some light on the innocent. I've heard that somewhere before.
Me too.
Not
That's
sure
funny.
Yeah.
Hello, everybody. Thanks for having me, Mark.
You're welcome. Dassey, I'm just a little concerned as to how you are today, given the prevalence of LED lighting. Does that description now befit you in a modern electrical environment?
I'm an old timer though. So.
That's right.
Yeah. I'll have to adjust the lyric. Yeah.
Yeah, you'll have to turn down the candle in the background there. I can see it's a bit bright.
That's the old sun. That's the sun up back there. So.
Oh yeah, I remember that. Yes, the sun.
Yeah, that's right.
Yeah. So welcome everyone, Carrie, Travis, and Denman, and to the people who have joined the chat so far. Thank you very much for joining. I'll ask my guests to keep an eye on the chat for questions. That's where we're going to get them from. But to kick things along, I wanted to actually ask a question of Travis, our attorney, our in-house attorney, I'll call him, at least for the next 45 minutes. And my question to you, Travis, was to do with evidence. One of the things that's always bugged me, maybe others, is that in these appeal-based matters, it seems to me that the state has the sole discretion as to which evidence it turns over, which evidence it would be prepared to give, in this case, Kathleen Zellner, to test or to examine or whatever. And it troubles me that that's a selective process that the state has control of. And I just wondered if you could give us all a background as to why that is, and is that typical of the law generally? Thank you, Travis.
So we're talking in the post-conviction time frame, right? About evidence being turned over for independent testing versus what evidence. So there's a whole different set of rules for evidence being turned over pre-trial, before the trial, and then after trial to test evidence. And in this specific case, the RAV and things inside the RAV and things found inside the RAV, the bullets that were found in the garage, those types of things. Kathleen Zellner wanted to test as part of her post-conviction efforts on behalf of Stephen. And so to answer that question, what determines what you're allowed to test post-conviction is typically by statutes, supplemented by case law. After the exoneration explosion based on DNA, you saw many states, including Wisconsin, pass evidence preservation laws, DNA testing laws, et cetera, et cetera. Wisconsin does have a DNA testing law. It was pushed very hard by the Wisconsin Innocence Project, WIP. And the gentleman that was instrumental in getting Stephen exonerated in his sexual assault case, same guy. They passed laws regarding DNA testing and evidence preservation of biological material. And so what really happens is these statutes and case law control what needs to get turned over. And if there's a dispute, then the circuit court, the trial court level judge, needs to resolve that dispute. As Kathleen said in MAM.2, it's always easier and better if you can get cooperation and agreement with opposing counsel, the state prosecutors. In this case, she was working with Tom Fallon and one or two of the other attorneys pretty closely. She had arranged to get item FL, the bullet fragment, had that tested for trace evidence and microscopic testing. And you saw that in MAM.2. There's no bone on it where there should be, according to the experts. Lots of other things that helped her in her case. She was in the process of working out an agreement to test the RAV and other items. And then, unbeknownst to anyone, the circuit court went ahead and issued its order denying her motion for post-conviction relief, which was subsequently appealed, and then that's where we're at now. So maybe the better question is why, even though the judge ruled against Stephen in the motion for post-conviction relief, the state could, I suppose, in Wisconsin, agree that even though you've lost, it's on appeal to save time for everybody. Let's go ahead and just test some of these items now in the interim. And it's usually never done because we're in an adversarial system in the United States, and it'd be like replaying a period of cricket pending the resolution of some dispute. Best analogy, we don't replay games. We don't start down a process unless we know for sure it's going to lead to a legal outcome. And I know that's probably not satisfactory for a lot of people, but in this particular case, that's why testing ceased. And
So
we're at.
Travis, would it be fair to say then that in post-conviction environment, the evidence that Kathleen Zellner is entitled to receive to test if she so wanted to is entirely at the discretion of the state?
No, it's set forth by statutes,
Yeah.
supplemented by case law. Now,
So if that's the case, then if she wanted to ask, I'll use a very topical matter. If she said, "I would like to have the RAV4 for testing and subject to due protocols, etc.," are they entitled to refuse her access to the RAV?
well, they can always try and argue, well, no, the statute doesn't apply to this. And in the West Memphis 3 case, that was a huge issue. They wanted to test the hair found in the knot of the shoe. And the state fought, and they fought tooth and nail, and they said the statute doesn't say what you said it does. And they went all the way to the Arkansas Supreme Court. Arkansas Supreme Court was asking the attorney for the state that was arguing the appeal, how could you possibly take this position? If that was what the legislature intended, there would be no testing of any DNA. But yet they argued that position. The Arkansas Supreme Court said, you're crazy. That's not what it means. You need to turn this stuff over for testing. The trial court judge needs to set a protocol to ensure the integrity of the evidence. And so the state can take a position. It was done in the Michael Morton case. They fought tooth and nail to prevent the DNA testing for years probably close to a decade. And then when that evidence was tested, a handkerchief found, 100 yards away from the murder scene inside of a home. They tested the blood on that handkerchief. It came back to the real murderer of the Mr. Morton's wife, and totally exonerated him. And yeah,
So what's the essence of the statute? Forget the
well,
case law just momentarily, but what's the essence of the statute that gives someone the right or the argument to receive the evidence for testing or to argue against receiving the evidence for testing?
so in Wisconsin, it's this evidence preservation statute that
Okay.
was spearheaded by the head of WIP, WIP, and it says, first they've got to maintain and preserve the evidence, biological evidence that may, uh, because of testing method improvements, new testing procedures and methods, may lead to an exoneration. So one, they're required to maintain the evidence. That's the first prong. Because if they're not required to maintain this, they could throw it all out with impunity and there wouldn't be any exoneration. So one, they're required to maintain it. And then number two, it sets forth procedures, and they won't let you test, for example, pizza that got collected at the crime scene.
So is the essence that if the evidence has biological value, in other words, there's something, then it's up for potentially to be tested by the other side. Would that be a fair thing to say?
Yes, and material,
Okay,
meaning
so relevant to the case.
that it can change the outcome.
Okay, so if I could drag you down to that specific point and to Stephen's case, in the case of the RAV4, which we know there was blood found, reported in many places in the vehicle and DNA on the hood latch, would you say as a lawyer that satisfies the test of a piece of evidence has biological connection and is key to the outcome of the case or to the decision-making process in the case? In other words, if you were Kathleen Zellner, would you be arguing, for example, that that's a relevant piece of evidence that you should have for testing?
Which particular evidence? The blood in the RAV?
Yes.
Okay, well, so that actually was the subject of an order during the court case, that those items of evidence be maintained and preserved and available for testing. So
yes.
There's never been any roadblocks with that, where Kathleen has done exactly as you have suggested. Filed motions for violations of the preservation statute is respect with the bones that were found in the quarry, and that some or all of those relevant bones may have been returned to the family and have been destroyed. And so she interrupted the appeal, asked the court to halt the appeal until those issues could be resolved. The circuit court ruled that no, these bones aren't relevant, they're not material, they can't lead to an exoneration. So now that issue is part of the appeal.
Okay, so I won't labour too much because we have a limited amount of time on this point, but would it be fair to say then, Travis, even though there may be biological evidence in the RAV4 of different types, that doesn't give necessarily Kathleen or the Zellner in this case, doesn't give her the right to test the RAV4 generally? She could only test the relevant biological material. Would that be fair to say?
Yes, but that it's not just DNA testing. So if she could show that trace evidence analysis of the parking light blinker assembly uh, could somehow lead to material evidence, she could have it microscopically and trace evidence analyzed, just like she did with the item FL, the bullet. So you're 100% correct, but it wouldn't be limited to DNA. It would be inclusive of all types of DNA testing that are all types of forensic testing that she could show might lead to material evidence.
Okay. So it really is a matter of either her requesting they agree, or if they don't agree and it's powerful enough, she could go to a court and ask them to enforce them to give them that evidence under the statutes.
Right, which is what she did with regard to the bones that were returned to the Hallbach family. And then the court ruled against her, surprisingly, and said, no, those aren't material. And so now that is part of the appeal that she has pending.
Okay. I thank you, Travis, for that. I just, if I could just ask, because it was the first question on our list here from people tuned in here. It is a legal question. In fact, there's quite a few but I've got to try to limit the range of questions. But could you just give us a 30-second synopsis, Travis, as to what does sealed evidence mean? Can you just explain the court's definition of what sealed evidence means?
Sealed evidence is evidence that normally evidence in a trial is open to the public. Anybody can go and look at it, especially the media.
Yep.
Certain types of evidence, either at the request of the defendant's attorney, the state, or even the judge, is sealed because it might be the identity of a minor child who is the victim of a crime. It might be horrible photographs. Autopsy photos are frequently sealed. Gruesome evidence that you would have to show the judge a good reason why you need those sensitive types of things. In this case, Zellner submitted evidence as part of her post-conviction appeal that she requested the court seal and remain sealed. I think those were related to searches on the Dassey computer regarding, adult material. No, those were sealed. Some certain items were sealed in the criminal court, and that's pretty standard stuff depending on what the items might be. But that's what sealed means, is that you can't go to a clerk's office and say, I'd like to look at exhibit 47. The clerk would say, I'm sorry, that's sealed pursuant to the order of the district court judge, or sealed pursuant to the appellate court judge. You would need to go talk to them.
I have to add something, if that's okay, about the sealing.
Carrie, can I just come back to you just in a quick sec,
Sure.
if I could? Just, Trav, just a supplementary, because it was part of Double D's question to you, is that can sealed evidence be subject to freedom of information requests?
No, sealed information, assuming the judge has authority and the jurisdiction to seal evidence, which I'm not aware of any trial court in the United States that doesn't have the authority to seal certain kinds of evidence. Now, can a newspaper go in and argue to a reviewing court that the items aren't appropriate for sealing, that they should be made public? Absolutely. It happens all the time. But it's not done under the Freedom of Information Act for the state. It's done under First Amendment, freedom of the press, the public's right to know. If people are really interested in that stuff, uh, Google Pentagon Papers, and you'll you'll learn really quickly about what can be sealed, how much the government can try and contain information, how much um, they can't. That's all been litigated in the United States, but you're not going to trump a court order with a freedom of information request.
Okay. Carrie, would you like to, I'm sorry, I interrupted you before. Would you like to add your piece to that?
Well, I'm curious because there are sealed records, such as the ones that he was talking about that Zellner even had put in her motion that were sealed. But there's also the Calumet County Sheriff's Department and DCI saying that there's sealed evidence, as in sealed in the package that it was collected in, and they don't want to open that seal. What are the legalities of those seals? Those aren't technically sealed by the court, just sealed by evidence tape. So what's the difference between that and sealed evidence tape? Like, they don't want to show us certain things because it's in an evidence sealed bag.
Yeah,
Could you give us
yeah,
a quick answer
yeah,
to that, please?
yeah. Let me answer it this way. Stephen and Zellner don't want people poking around in stuff. If it's sealed in envelopes, like let's just say the vial of blood from Stephen's first trial, and all of the problems. His first case in MAM.101, you saw that they went down and they were allowed to view that vial of blood that got him exonerated in the sexual assault case. They were allowed to look at it because they got a court order to do it. We don't want people off the street opening bags and pulling stuff out of envelopes. The public doesn't have a right to look at that stuff.
Let's say it's a recording of one of the interviews.
Yeah,
Should the public have a right to listen to those interviews?
I don't know what their statutes are on. My understanding was that if it's an exhibit in a trial, regardless of whether it's a DVD video, it's a CD audio, that at least it's this way in Texas, if it's not sealed, if it's audio, then it should be available to be copied. They generally don't let the public copy it. You have to, they'll either have a third party duplicating service that it gets sent to that's contracted by the clerk, or they have the machinery, the equipment to do it internally. But that's my understanding. And so the next question mark is going to be, well, how do you get them to comply with that order, or that law, if that's in fact the law in Wisconsin? And this is what I have a difficult time explaining to people. What you need to do is hire a lawyer to file a writ of mandamus to force the clerk to do it. Short of that, there's nothing you can do.
Okay. Thanks, Carrie. Thanks, Travis. I'm very mindful of the time, but if we do need to go a little longer, I'm happy to if everyone else is. This is a question, I might direct it to Dassey, because this is a kind of a general question that anyone could have a view about. And this is asked by Donna. She says, what does the panel think about the disclosure of the emails in relation to the 8mm flyover tape? Yeah. Do you think if it had proven anything for the state, would they not have disclosed it?
Well, it ties in, for me, that subject ties in with what we're talking about. Travis was just saying is, to me, if they withheld it, there's probably.
Stace, I'm having a little trouble getting you. Looks like Travis and Carrie, are you having trouble hearing Stace there?
I think he fell out.
Yeah, he's buffering on my screen.
Yeah.
Carrie,
you might like to offer your. Oh yes, you back there, Stace?
Hey,
we were.
Hey, Mailer,
yeah, we were.
Yes.
Maybe I could.
Stace,
maybe
you're on mute.
You're not now.
I'm here.
Stace.
Oh, there you are.
Yeah.
Yeah.
Stace, could I just get you while we've got you? We'll keep going. But if we have trouble with you buffering, which is what's going on, we might just get you to flick the video part off, and that might help. Just so we can hear your response.
It might have been. I just turned my computer because I was watching YouTube as well. So.
Hey, let's do it.
Maybe I will. How's that?
Okay. Yeah. So yes, give us your thoughts about the 8mm tape.
Can you hear me?
Yes, very good. Thank you.
Well, I think they can. They're withholding things, but to me, the question comes to how do you act, or how do you react when it seems the state is always acting in bad faith? There's example after example of withholding evidence, agreeing to things, and so the 8mm tape, although on its surface kind of is a red flag or something, but I'm certain that the state can argue their way out of it. And but to me, the examples are they continually are caught in situations that look like they're trying to withhold or obstruct the truth,
Carrie, your thoughts?
I agree. I think if it had proven anything for the state, it would have been used. The fact that they hid it means that there might be something on there that proves something for the defense. It seems like they hide all that evidence.
Yes. And Travis, the same question from a legal perspective. Also, Millbilly is asking what your thoughts are about the 8mm tape as well. Prominent evidence. Trav, you're on mute, mate. You need to unmute yourself.
So from an evidence standpoint, now we're talking about pretrial evidence, and that's governed by Brady. And Wisconsin actually, with that decision by the Wisconsin Supreme Court regarding Brady, they're in the forefront on Brady law in the U.S. in the defendant's favor. And they've ruled that you had to show a bad intent, bad motive on the part of the state for not turning things over. And they've led the nation in eliminating that requirement. And so you're generally required to turn over anything that's exculpatory. And if you don't, you're subject to having the case overturned, unless there's just overwhelming evidence on top of that. And so Brady is the significant issue in this case. Now, Kathleen didn't raise, I don't believe, any issues with regard to the flyover video, but it's clear. I remember commenting on it with friends when MAM.101 came out, that one video, I'm a pilot. One video is clearly from a helicopter, and the one video is clearly from an airplane. There's, I think, 4 hours of video from supposed to be from an airplane. A private person went up in his airplane with law enforcement, and they shot video. And so it's clear that the video that's being referenced is spliced together. And as to Millbilly and others would know much better what is supposed to be on that material that might be exculpatory. And I think it has to do with if we know what time the video was shot and they're over the area that the RAV was eventually found, yeah, that would have great evidentiary value. Depending on how it came out, it might be exculpatory or not. But in my view, that's something that should have been turned over. But I don't think it's part of the appeal.
I think she did mention it though in her email. She wanted the full flyover video, and they told her that you have what we have, and then he turned around and wrote an email, we need to find that 8mm tape. So they were talking about it because of Kathleen Zellner asking for it.
Do you remember, Carrie, if it's in the brief, her appellate brief, or part of the state's opposition?
I'm not sure if it was in the actual brief, but it was in her emails to them.
Yeah, I don't think it's part of the appeal.
Because they said they had the full tape. So would it be in the appeal now that they find out that there's an 8mm tape that they didn't tell her about it? They just talked about it behind the scenes to each other in an email. Could that be included into this case now that there's notes of this 8mm tape?
No.
She can't go and claim a Brady violation on that too?
Not now.
Can she add it? She could always go back to that at another time.
Would it have to go back to the circuit court for that?
Well, she would have to show, in order to get over the procedural bar, she would have to show why she didn't raise it up till now. And there would have to be a good reason.
Because she didn't know about it till now.
But wait, you said she raised it in an email.
Yeah, and they told her that they had what she had is what they had, and then they turned around not to her but to each other about this 8mm videotape that they need to see if it's working.
And then, so if that turned out to be the case, she asked for material. They said, no, you have everything that we have, and that turned out not to be the case, then she could go for another, she could bring another post-conviction motion, because it would not be procedurally barred, presumably. She wasn't aware of it, has a good reason not to be aware of it. Came out later that this stuff existed, and did ask for it. They denied its existence. That can be grounds to file a subsequent, but the materiality of it is what's, that's not going to probably break the case.
What if it showed that the RAV was not there on the property the day of the 4th, and they're saying it was parked there this whole time? Wouldn't that show that it was moved there later? Wouldn't that be like have a different outcome to the case then?
Potentially, yes, but if that video showed the RAV not there when they said it was, it could be different too. That RAV could be there maybe earlier than what fits the state's case, and that could be problematic for them too. Kathleen has gone with the theory that it was driven in, followed by a white Jeep type SUV through that property, and then came out. There's taillight evidence that Stephen talked about, and his brother phone call about, hey, did you see those lights go through the property? A car blocking the area. So Kathleen's got that theory.
Travis, could I just ask you just a little bit, again, being mindful of time?
Sorry.
The essence of the issue is the discovery of emails clearly showing the existence of another recording of the flyover video, an 8mm recording, we're told, through the email, internally between the state's departments, not to Kathleen. Isn't that of itself evidence of with the withholding of evidence in terms of the trial matters, in other words, a Brady violation, and therefore that matter could be brought back in as another post-conviction petition as well, if need be?
It could be. It sounds like the first prong is met, but you'd have to, we don't know enough to know whether the second prong of materiality is met.
Okay, well, that'll be a matter of discovery, I guess. Once you can only know the materiality once you see the video, correct? So I have another quick question here. This does require, it's a legal question, but it can be answered in a yes/no response, and that is it in the circumstances of a post-conviction new trial, are there cases where those trials, due to potential prejudice of matters, are held in a state other than the original state where the trial was first held? Or is it always going to be in Wisconsin in the case of Stephen?
In this case, it's always going to be in Wisconsin. The only time you can move a case out of a state is if it's a federal case.
Okay, thank you. Another question.
Well, wouldn't it go to federal court too? Also, if they're like denied at the appeals level, they can then appeal to the federal court in Chicago, like Brendan did.
Yes, but that's not for purposes of trial.
Okay, gotcha.
That's a federal post-conviction habeas corpus. So in terms of a trial, it will always be in Wisconsin.
Okay.
That's a bummer for him.
Another question from Kelly. Again, if a quick answer, if you can. I'm sorry, I know legal matters aren't quick answers, but would it, in the circumstances of biological evidence and the handing back of these bones to the Hallbach family, I won't go into the issues of custody, the chain of custody, but would that be, if those bones exist in a buried form in a memorial for Teresa, as hard as that may seem, would those bones also be potentially at least capable of being exhumed for examination? Just a quick reply, Trev.
Yes, and it's a great question. That goes to what the heart of Kathleen's appeal is, which is send it back for evidentiary hearing. All of those answers all of that could be answered in an evidentiary hearing. So we don't know 100%, but that's why she wanted an evidentiary hearing. And that's a major part of her appeal, is that questions like you just read could be answered.
But how would they tell then, like after it's already been returned? It's not like the family's going to keep it in the little sealed envelopes and boxes and stuff.
Well, we don't. Yeah.
Then would they lose their chain of custody? Because she wants to specifically test the ones from the quarry. How would we know which ones are then from the quarry if they've been given back to the Hallbachs and buried?
Yeah, and how that issue is framed in the appeal is that she should have been allowed to have an evidentiary hearing on it, and she wasn't. So we don't know. And those questions that Carrie just asked are excellent questions, and they're the types of questions that Kathleen raised both in her motions before the trial court and in her appeal.
Okay, thank you. This is a general question. It's not based in, if you like, facts or it's just observation from Zuckmir 123, asking, and Carrie, I might just ask you for your observation. And the question is whether we have any thoughts as to why, in the opinion of the person asking this question at least, the Hallbach family appear so united against Stephen and Brendan. It's very
I personally think they were manipulated by the police to believe that it was Stephen and Brendan, and they're going to have a hard time. They're going to have a hard time when they find out it wasn't Stephen and Brendan, because I don't think they'll ever get any true justice for Teresa after that. I just think they are just denial. It's a denial, you know. They want to think that she's got her justice, and they don't want to upset that feeling, I think. In my opinion, I don't know for sure. I mean, I wish they'd look at the case more detailed, but I
Yes.
really couldn't tell you what they're thinking.
Yeah, it's an interesting issue, but
I will say Pagel is somewhat related to the Hallbacks, and he was the sheriff. His niece, who's close in his age, is married to one of the Hallback relatives, her uncle. So I do believe there's somewhat of a connection there, and I think that they wouldn't believe that, you know, Pagel would lie to them because he's somewhat family. So I think that's how they got manipulated real easily.
yep.
I agree with what Terry says, except it doesn't take any manipulation. The DA tells you, you know, we've got the right guy. If the police tell you we've got the right guy, that's what you go with if you're the family of somebody who's been murdered. I mean, there's just no difference among them. And until you get solid evidence out there working for you, this happened in the Westminster Street case. And the family finally shifted when you had exoneration for the evidence. I'm not saying there wasn't manipulation, but you know, I've practiced in a lot of small towns around Texas, and uh, everybody knows everybody. Everybody is related to everybody in these small towns. Everybody went to school with everybody in these small towns. Um, it's, yeah, and you typically have people that live on one side of the track, and you have others that are on the other side of the track. And it's uh, that really is what is most exciting. Um, that you have these two factions, and it doesn't take any manipulation to have the family of somebody who's been murdered be lined up with uh, the prosecutors and law enforcement.
Thank you, Travis. I've got a question here. I think I'm reading this correctly from Millbilly. Just making a comment, really. Travis, you might actually have a view about this, or at least can cast some light on this. Millbilly's talking about there has been recently law passed limiting federal freedom of information applications via the Supreme Court, and a Supreme Court opinion limiting freedom of information applications. Are you aware of that? And hopefully, Millbilly, I've interpreted your question correctly.
So he asking the Supreme Court of Wisconsin on the Wisconsin Freedom of Information statute, or talking about the U.S. Supreme Court on the federal?
Unfortunately, I can't. The question isn't as illuminating as that you need it to be to give a full answer. But I think he's referring to federal freedom of information requests.
I'm not familiar with the case.
Yes.
Millbilly.
Yes. Sorry, Travis. Yes, he's just confirmed it is the federal, or as he's written, federal level.
Okay.
Federal level.
No, I'm not familiar with it, but Millbilly, send it to me and I'll be happy to review it. But that, if it's interpreting the Federal Freedom of Information Act, FOIA, it's not going to have any impact on what the state of Wisconsin is willing to give up. They have their own statute.
Okay. All right. I'll just picking out some other questions here. Let me just see this for a sec. From Double D, a question, again a legal question. Is there a law indicating that judges should remove themselves from the case if they had any previous dealings with the case in the past? This is, I guess, a conflict of interest question. I presume they would need to disclose and show how they're going to deal with it.
Yeah, it depends on the context. So if a judge had presided over a criminal case and somebody was convicted, then that defendant is back in front of that same judge. No, there's nothing to prevent that. Generally, the conflicts laws come around. They're probably referring to
Mark Gundrum, because he's a judge now. He was.
yeah, and
Yes.
I don't think Gundrum's going to be assigned to the panel. Although I think that would have been good for Stephen if he was on the panel, but he'll probably remove himself. I think what they're talking about is who we refer to as Judge Flowers and Eve Chitalowicz, and the fact that she had made a couple of rulings in a civil case about or delayed ruling on signing a dismissal in
Yes.
the wrongful death case against Stephen. And now she's hearing the post-conviction case. In Texas and other jurisdictions I've practiced in, that would be insufficient to be automatic grounds for what we call recusal. She could.
But I mean, what about their professional standards? I mean, they must have some, irrespective of the law, do they?
Yeah, no, there's professional standards on recusal where it's automatic. And then every state's a little bit different. And so the hard and fast rules are you can't be within a certain degree of consanguinity. You know that term, Mark. I'll let you explain it. But you can't preside over a case that your son or your spouse is one of the parties.
Yes.
So those are the automatic rules. And then generally most courts say, or if it will raise the appearance of impropriety, ruling on a civil dispute and delaying signing that dismissal would not raise an appearance of impropriety from a legal standpoint that's sufficient to cause a recusal of her presiding over the criminal case. Now, Kathleen has filed a motion to recuse on her once, which was opposed by the state and denied by Judge Flowers. You get an automatic recusal in Wisconsin where you're allowed to kick off the judge initially assigned for any reason or no reason. And that's not me, that blower.
No, that's my end of the thing. Is a ultralight flying over the back.
Awesome. Okay. Well, so it does. No one else can probably hear it. Just these headphones. Anyway, so that was denied, but because of the timing on it, and so if this case is reversed and sent back, there is a chance that she may be able, under that statute, to recuse the judge. But I have not looked at that at this point. Or the appellate court did even rule that we don't find that the judge appears to be free of bias. This needs to be sent to another court. That's pretty rare for an appellate court to say that, but I've seen it done.
Okay. Thank you, Travis. I'm mindful of the time, and I also note for some reason Dassey's disappeared. He might have had a computer problem. So I'm going to, in a few moments, wrap up the discussion. Before I do that, Carrie, were there any other general comments you would like to make about the case, perhaps the status of the case, or matters that are still on your mind and troubling you about things that we haven't yet had proper answers to?
Just one?
Well, I know there'll be many, so give me a couple of your best ones.
I think I don't think I have any questions off the top of my head though. That I can think of that, you know, just free them already. I mean, what's taking so long? You know.
Exactly. Travis, what about yourself? Have you got any kind of, from a personal point of view or a legal perspective, anything? If someone was to stop you in the street and say, you get onto the subject of making a murderer and you get past the basics, and what might be one or two of the burning issues still in your head that trouble you about this case, apart from the ultralight?
Well, one was the this high threshold that they required in Wisconsin to have legitimate guinea suspect, and I won't get in. It's too convoluted what a guinea suspect is, but in Wisconsin, that's the case. Guinea, in order to point to a third person and say, yeah, we think it's the people that live in this house on the property that were behind that. The judge excluded that and didn't let them point to another probable suspect. That's one big issue I had on it. And then the other is there seems to be a lot of manipulation with bone evidence and the testimony regarding the bones that I'm troubled about.
Okay, indeed. Thank you once again, Carrie and Travis, and to Stacey as well. Unfortunately, he's not with us at the moment. But I thought I might enjoin him to the conclusion of this broadcast by seeing if I can relatively seamlessly, which is not easy for me, maybe play one of his pieces of music to see us out here. And I'm going to try to open that somewhere here and see how we go. Can you hear this? Can you hear this? Can you hear this, everyone?
I can hear it.
Great.
Let's keep talking about Avery.
I'll come back to everyone when this is finished.
You just listen, I think you'll see why it matters. It really matters. Put aside the documentary, the state's version ludicrosy of all their claims so blatantly get torn to tatters. I say that matters. I bet you heard about Hood last sweat, but maybe you ain't heard this yet. 19 more times the DNA that was left anywhere else that day. I think that matters. I really do. I think it matters. An ex-boyfriend with a day planner page, and yet they did not investigate. And who knows why, and who can say why he was signed into the crime scene that day. I think that matters. I really do. I think it matters. How about that barrel that once was seized, but then returned to the Averys? The bones were found a documentary. The state's version ludicrosy. Oh, all their claims so blatantly get torn to tatters.
Well, I think everyone that we would totally agree with Dassey that we need to keep talking about Avery and Brendan, of course. So it's a very important issue that we do keep talking, and I hope this session today has helped facilitate that discussion. And to Carrie and Travis, thank you so much for participating today. And we will be having another session probably in a few weeks' time. Thank you to everyone who's participated in the chat on the side. It's very helpful to have all those questions come in. Please enjoy the rest of your weekend, and once again thank you to Brad Dassey for doing the intro earlier on in this session. So thank you everyone. Travis and Carrie, you just stay online there for a moment while I exit, but once again, all the best. Take care.
Bye.
Hey guys, we're not, whoops, now we're